Start.
Good morning, everyone. The topic for today's presentation is Mental Healthcare Act, and it's part 1. And the moderator is Dr. Shubhit.
So very important topic.
So the summary for Mental Healthcare Act today is enforcement. The changes in the Mental Healthcare Act 2017, and its 7 chapters, which include the preliminary, mental illness and capacity to make mental health care and treatment decisions, advanced directive, nominative representative, rights of person with mental illness, duties of appropriate government, and central mental health authority. Now, what is mental health care? Mental health care includes analysis and diagnosis of person's mental condition and treatment, as well as care and rehabilitation of such person of mental illness or suspected mental illness. As per Mental Health Care Act 1987, it came into effect in all states and union territories of India in April 1993. So, Mental Health Care Act in 1987 was not adequate to protect the rights of persons with mental illness. According to 1987 Act, the Mental Health Care Act was defined as an act to consolidate and amend the law relating to the treatment and care of mentally ill patients to make better provisions with respect to their property and affairs. So on 7th of April 2017, received the assent of the Honorable President of India and came into force on 29th May 2018. The other important dates are 16th of August 2019, where guidance document for assessment of mental capacity and list of drugs notified under Mental Healthcare Act was notified, and 18th December 2020, when mental healthcare regulations of Central Mental Healthcare Authority was notified. Now, as per Mental Healthcare Act 2017, it's an act which provides for mental health care and services for persons with mental illness and to protect, promote, and fulfill the rights of such persons during the delivery of mental health care and services and for matters connected therewith or incidental thereto. According to the Act, mental illness indicates a substantial disorder of thinking, mood, perception, orientation, or thoughts that grossly damages judgment, behavior, capacity to recognize the reality, or ability to meet the usual requirements of life. Mental illness cannot be decided by persons' political, economic, or social status, racial or religious groups, with the community's moral, social, and cultural work and religious opinion. It includes mental illness associated with abuse of alcohol and drugs, but it excludes mental retardation. Now, what are the changes in Mental Healthcare Act 2017? Initially, there were 10 chapters and 98 sections. Now, there are 16 chapters and 126 clauses. The Mental Healthcare Act for the first time clearly articulates the rights of persons with mental illness as per section 18 to 28. And the Mental Healthcare Act for the first time clearly articulated the mental capacity, advanced directive, nominative representative, and rights for the person with mental illness. Now the chapter 1 is preliminary. Act may be called as Mental Healthcare Act 2017 and shall extend to the whole of India. In this act, unless the context, it requires an advanced directive, appropriate government authority, which includes the Central Mental Health Authority and the State Mental Health Authority, board, which includes the Mental Health Review Board, the magistrate, the medical officer in charge, mental health professional, psychiatrist, psychiatric social worker, mental health nurse, medical practitioner, clinical psychologist, family caregiver, and relative. The chapter 2 includes mental illness and capacity to make mental health care and treatment decisions as per section 4. Now, determination of mental illness. No person or authority shall classify a person as a person with mental illness except for the purposes directly related to the treatment of mental illness or in other matters as covered under this Act or any other law for the time being in force. Now, mental illness of a person shall not be determined on the basis of political, economic, or social status or membership of a cultural, racial, or religious group, or for any reason not directly relevant to the mental health status of the person, non-conformity with moral, social, cultural, work, or political values, or religious beliefs prevailing in a person's community. Now, the past treatment or hospitalization in a mental health establishment through relevance shall not by itself justify any present or future determination of a person's mental illness. The determination of a person's mental illness shall not imply or be taken to mean that the person of unsound mind unless he has been declared as such by a competent court. Now, the capacity to make mental health care and treatment decisions. Every person, including a person with mental illness, shall be deemed to have the capacity to make decisions regarding his mental health care or treatment if such person has the ability to understand the information that is relevant to take a decision on the treatment or admission of a personal assistance, appreciate any reasonable foreseeable consequence of decision or lack of decision on the treatment of admission or personal assistance, communicate the decision by meaning of speech, expression, gesture, or any other means. The information shall be given to a person using simple language, which such person understands, or in sign language or visual aids, or any other means to enable him to understand the information. Where a person makes a decision regarding his mental health care or treatment, which is perceived by others as inappropriate or wrong, that by itself shall not mean that the person does not have the capacity to make the mental health care or treatment decision. So, as long as the person has the capacity to make the mental health care or treatment decision. Now, the chapter 3 is Advance Directive. Every person who is not a minor shall have the right to make an advance directive in writing specifying any of the following only: the work, the way the person wishes to be cared for and treated, the way person wishes not to be cared for and treated, and can appoint a nominated representative in order of precedence. An advance directive may be made by a person irrespective of his past mental illness or treatment for the same. An advance directive shall be invoked only when such person ceases to have the capacity to make the mental health care or treatment decision and shall remain effective until such person regains the capacity to make mental health care and treatment decisions. Any decision made by a person while he has the capacity to make mental health care and treatment decision shall override any previously written advance directive by such person. Any advance directive made contrary to any law for such time being in force shall ab initio void. Maintaining an online register. Every board shall maintain an online register for all the advance directive registered with it and make them available to the concerned mental health professional as and when required. An advance directive may be revoked, amended, or cancelled by a person who made it any time. And the procedure for revoking, amending, or cancelling an advance directive shall be the same as for making the advance directive. The advance directive shall not apply to the emergency treatment, and it shall be the duty of every medical officer in charge of the mental health establishment and the psychiatrist in charge of a person treatment to propose or give treatment to a person with mental illness in accordance with a valid advance directive. Revocation, amendment, or cancellation of the advance directive. Where a mental health professional or a relative or caregiver of a person desires not to follow an advance directive while treating a person with mental illness, such a mental health professional or relative or a caregiver of a person shall make an application to the concerned board to review, alter, modify, or cancel the advance directive. Power to review, alter, modify, or cancel advance directive. Upon receipt of the application, the board shall giving an opportunity of hearing of all concerned parties with either upload, modify, alter, or cancel the advance directive after taking consideration the following: whether the advance directive was made by a person out of his own free will and free from force, undue influence, or coercion, or whether the person intended the advance directive to apply to the present circumstances, which may be different from those anticipated. whether the person was sufficiently well informed to make the decision, or whether the person had the capacity to make the decisions relating to the mental health care and treatment when such advance directive was made, whether the content of the advance directive is contrary to the other laws or constitutional provisions. Now, the legal guardian shall have the right to make an advance directive in writing in respect to a minor, and all provisions relating to advance directive shall apply to such minor till such time he attains majority. Now, what is the liability of a mental health professional in relation to advance directive? Medical practitioner or mental health professional shall not be held liable for any unforeseen consequences on following a valid advance directive, and the medical practitioner or mental health professional shall not be held liable for not following a valid advance directive if he has not been given a copy of a valid advance directive. Chapter 4, which includes a nominative representative. Every person who is not a minor shall have a right to appoint a nominative representative, made in writing or a paper with person's signature or thumb impression of a person and registered with Mental Health Review Board. The person appointed shall not be a minor, be competent to discharge the duties or perform the functions assigned to him under this Act. He should give his consent in writing to the mental health professional to discharge his duties and perform the functions assigned to him under this Act. Where no nominative representative is appointed by a person, the following person for the purposes of this Act in order of precedence shall be deemed to be nominative representative of a person with mental illness. The individual appointed as nominated representative in the advance directive, they can be a relative, a caregiver, a suitable person appointed by a concerned board. If no such person is available to be appointed, then the board shall appoint the director, Department of the Social Welfare, and his designated representative as a nominated representative. A person who has appointed any person as a nominated representative under this section may revoke or alter such appointment at any time. The board may, if it is in the interest of the person with mental illness to do so, revoke an appointment and appoint a different representative under this section. The appointment of the nominative representative or inability of a person with mental illness to appoint a nominative representative shall not be construed as a lack of capacity of the person to take decisions about his mental health care or treatment. All persons with mental illness shall have the capacity to make mental health care or treatment decisions, but may require varying level of support from the nominative representative to make decisions. Now, nominative representative of a minor. In case of minors, the legal guardian is a nominative representative, where on an application made to the concerned board by mental health care professional and on evidence presented before it, the concerned board is of the opinion that the legal guardian is not acting in the best interest. The legal guardian is otherwise not fit to act as the nominated representative of a minor. It may appoint any suitable individual who is willing to act as such. The nominative representative of the minor with mental illness board shall appoint the director of the Department of Social Welfare of the state in which such board is located or his nominee. Now, the duties of the nominative representatives are they have to consider the current and past wishes, the life history, the values, the cultural background, and the best interest of the person with mental illness. Give particular attention to the views of the person with mental illness to the extent that the person understands the nature of the decisions under consideration. He should provide support to the person with mental illness in making treatment decisions and should have the right to seek information on diagnosis, treatment to provide adequate support to the person, and have access to the family or home-based rehabilitation services behalf of and for the benefit of the person with mental illness. He should be involved in the discharge planning under Section 98, apply to the mental health establishment of admission under Section 87 or Section 89 or 90, apply to the concerned board on behalf of the person with mental illness for discharge under the Section 87, 89 or Section 90. He should apply to the concerned board against violation of rights of persons with mental illness in a mental health establishment. He should appoint a suitable attendant and have a right to give or withhold consent for research under circumstances. Now, the chapter 5, which includes rights of persons with mental illness under section 18 to 28. Now, the rights first is the right to access mental health care. As per section 18, and the treatment for mental health care services at affordable cost and without discrimination. This includes the provision of acute mental health care services such as outpatient and inpatient services, provision of half-pay home, sheltered accommodation, supported accommodation, provision for mental health care services to support family of the person with mental illness or home-based rehabilitation. They have to provide hospital community-based rehabilitation establishment and services. Provision for child mental health services and old age mental health services are also provided. The government shall integrate the mental health services into general healthcare services at all levels of the healthcare and provide treatment in a manner to live in a community and their families. Ensure that the shortest treatment course possible for the patient. Ensure that no person with mental illness will be required to travel long distances to access the mental health care services. Ensure that the mental health services run or funded by the government shall be available in each district. Persons with mental illness living below the poverty line who are destitute or homeless shall be entitled to mental health treatment or services free of any charge. The mental health services shall be of equal quality to other general health services, and the government shall notify essential drug list or all medicine shall be made available free of cost to all persons with mental illness at times at health establishment. Now, the right to community living under section 19. Every person with mental illness have a right to live in, be a part of, and not segregated from the society. Not continue to remain in a mental health establishment merely because he does not have a family or not accepted by his family or is homeless or due to absence of community-based facilities. If not possible for any mental health person to live with his family, the government shall provide support, legal aid to facilitate exercising his right to family home and living in a family home, to provide for or support the establishment of less restrictive community-based establishments. Now, right to protection from cruel, inhuman, and degrading treatment, right to live with dignity, to live in a safe and hygienic environment, to have adequate sanitary conditions, to have reasonable facilities for leisure, recreation, education, and religious practices, to privacy, to proper clothing as to protect such person from exposure of his body to maintain his dignity, and not to force to undertake work in a mental health establishment and to receive appropriate remuneration for work when undertaken. To have adequate provision for preparing for a living in community and to have adequate provision for wholesome food, sanitation, space and access to articles of personal hygiene, in particular women's personal hygiene, be adequately addressed by providing access to items that may be required during menstruation. To not be subject to compulsory tonsuring, shaving of the head hair, to wear own personal clothes if so wished, and not to be forced to wear uniforms provided by the establishment. To be protected from all forms of physical, verbal, emotional, and sexual abuse. Right to equality and non-discrimination under section 21. Every person with mental illness shall be treated equal to persons with physical illness. There should be no discrimination on any basis, including gender, sex, sexual orientation, religion, culture, caste, social or political beliefs, class, or disability. Emergency facilities and emergency services for mental illness shall be of the same quality and availability as those provided to the person with physical illness, and person with mental illness shall be entitled to the use of ambulance services in the same manner, extent, and quality as provided to the person with physical illness. Living condition health establishment shall be of the same manner, extent, and quality as provided to the person with mental illness, and any other health services provided to the person with physical illness shall be provided in the same manner, extent, quality to the person with mental illness. The child under the age of 3 of a woman receiving care, treatment or rehabilitation of mental establishment not to be separated from her during her stay in such establishment. If there is risk of harm to the child from the woman due to her mental illness, the child shall be temporarily separated from the woman during her stay at mental health establishment, and the patient shall be reviewed every 15 days during the woman's stay in the mental health establishment. Now, right to information. Every person with mental illness and his nominated representative shall have the right of the following information: to know the criteria of admission under which the patient is admitted, to make the application to the concerned board for the review of admission, to know the nature of person's mental illness and proposed treatment plan, which includes information about treatment proposed and known side effects of the proposed treatment, to receive the information in a language and form that such person receiving the information can understand. In case complete information cannot be given to the person with mental illness, at the time of it is the duty of the medical officer to ensure that the full information is provided when the individual is in the position to receive it. Now, the right to confidentiality. Duty to keep all the information confidential, released of information to the nominated representative to enable him to fulfill his duties under this Act. Release of information to mental health professionals and other health professionals to enable them to provide care and treatment to the person with mental illness. Release information if it is necessary to protect any other person from harm or violence. Only such information that is necessary to protect against the harm identified shall be released. Release only such information as is necessary to prevent the threat to life. Now, the right to assess medical records. There is to assess the basic medical records. The mental health professional in charge of such records may withhold specific information in medical records if disclosure would result in serious mental harm to the person with mental illness or likelihood of harm to other persons. Right to person contact and communication. Have the right to refuse or receive visitors, make telephone or mobile phone calls, send and receive mail through electronic mode, including through email. They have a right to legal aid, and they have a right to make complaints about deficiencies in provisions of service. Any person of mental illness or its nominated representative have a right to complain regarding deficiencies in the provision of care, treatment, and services in a mental health establishment to the medical officer, to the board, and the state authority. Now, chapters 6 include duties of the appropriate government. They have a duty to, as the promotion of the mental health and prevention programs, the government have a duty to plan, design, and implement programs for the promotion of mental health and prevention of mental illness in the country. The government to implement public health programs to reduce suicides and attempted suicides in the country. Creating awareness about mental health and illness, reducing stigma associated with mental illness. The government shall take all measures to ensure that the provisions of this Act are given publicity through public media, including television, radio, print, and online media at regular intervals. The programs to reduce stigma associated with mental illness, and the government officials, including police officers and other officers of the government, are given periodic sensitization and awareness training on the issues under this Act. The government takes measures to address the human resource requirements of the mental health services in the country and to increase the human resources available. To train all medical officers in public healthcare establishments to provide basic and emergency mental health care, and the government shall take all measures to ensure effective coordination between services provided by concerned ministries and the departments. Chapter 7, which includes the Central Mental Health Authority. It consists of a secretary or additional secretary to the Government of India, the Joint Secretary to the Government of India in the Department of Health and Family Welfare, the Joint Secretary to the Government of India in Department of Ayurveda, Yoga and Naturopathy, Director General of the Health Services, the Joint Secretary of the Government in the Department of Disability Affairs of Ministry and Social Justice, the Directors of Central Institutions of Mental Health members ex-officer, such other ex-officio representatives from relevant center government ministries or departments, one mental health care professional as defined in the item having at least 15 years of experience in the field to be nominated by the central government. One psychiatric social worker having at least 15 years of experience in the field to be nominated as central government member. One clinical psychologist having at least 15 years of experience in the field to be nominated by the central government. One mental health nurse, 2% representing persons who have had mental illness to be nominated by the central government. 2% representing caregivers of the person's mental illness or organization representing caregivers to be nominated by the central government. 2% representing the non-governmental organization and 2% representing the areas relevant to mental health if considered necessary. So this is the reference. Get it.
Thank you, Dr. Tanya. So any questions, comments, clarifications, doubts? House is open. This is the most important thing, the most important section to discuss, because you all have to abide by it. Mental health board has been already framed. They have actually framed their state mental health draft also, which they have released in social media website channels, the comments, and they have invited each and every district some boards which will be district wise made. So they will also be finalized. So very sooner than expected, we will have to follow all these.
What is your critique of the act? Describe that. What do you think that you describe? Your for example, right? Issue that geographical access. You should not travel far. You should distribution to the get free. So it is now in the law. Okay. So if there is a law that you can go to court if you're not getting that. If somebody is not getting treated, you can go to court. How do you see this law? Is it applicable? Can you
person with mental illness, they are not aware of that. The people belonging to low socioeconomic status, they don't know about the mental illness. So we should aware them about the rights they have. They have access to every possible treatment. And
if a patient comes to you and he says that I'm below poverty line, private practitioner, and he says I will not pay because I have to get it. So where do you stand? Can you ask for a fee, or like the patient comes in, they are limited, he said I will not pay the fee. Because that says that I should pay the fee.
then I should.
Just like the people who care. Access to material. तो ये क्या होगा? सर आपका यहाँ पे हॉस्पिटल है, so you have to make.
Many times this issue has raised. One of the patient was left in the call from someone who left a patient. He was to be South State, so we need to have some psychiatric issue what to do with it. And ideally, as per the law, we should give the treatment services free of charge because he was a destitute. Probably just left there by some of the people who found him outside.
The government shall. It is the responsibility of the doctor, the hospital. They have also their rights. As a physician, you have a right to charge fee from that. You have a right to earn a livelihood. Not earn a livelihood by making profit. So the hospital physician has the right to charge fee and if you are a private practitioner, then you are not, unless and until something is built in. Like for example, in right to education, it is built in that 10% of the seat should be reserved for the economic poor. So schools have to do that. If such thing would have been built here that we have to give 5%, 10% of the patient or something like that, but it is not there in the act. Okay, we don't have to like, we don't have to give them free. We don't have to change anything from our no, or any person who is private practice. It is not built in that you have to treat them at discount or you have to treat them free or 10% of the patient you have to treat them. It is not in the act. It's the government's responsibility. The government has to issue. Or the government will say that we will pay you back. Okay, that is then in some acts like this RT with right to education, 10% of the seats. So that's kind of the same.
Subsequently, this was called, the patient was taken to Sila.
That's the government, yes.
So the government needed to be instructions.
So it's the responsibility of the that they have to be given.
We should ask the patient to go to government
Yes.
hospital.
We should ask the patient to go to a government hospital or a government aided hospital. Okay, that where you can refer that patient. Although it is not in that. Second thing is that advanced directives. Okay. So they say that that advanced directive will be available online
Um,
for the access of the physicians. Okay. Navigated patient comes, he admitted 3-4 days after admission, they give him the and if it is found that here in the advanced directive that I should not be given this. So should we attend that case? What should we do?
The mental health professional is not liable if it is not given at that valid time. The advanced directive is not.
So he should be informed at the time of admission
Time of
that I have denied us. It may not be in that sound state. You have to make an effort. We should have. We don't have an online form where we can go and check. That is again the state's responsibility. But if you are in knowledge of this, then you can't do it. Yeah, but there are provisions in this where you can go against advanced directive. There are procedures for that.
emergency treatment.
Emergency treatment where you think that it is overriding, then the nominated representative can take a decision that overrides advanced directive. But for all the other cases, like you can't just do it without any reason. There should be a valid reason for that.
So what is an advanced directive and what is how does different from nominated directive?
Advanced directive is the patient's wish, how he wishes to be cared or not to be cared. But a nominative representative
Is the person who has been given an authority to take decisions in advanced directive the same as nominated.
They would not say that.
we only appoint for nominative representative
In order of precedence, क्या हुआ?
as per the relations, like the relatives, the caregiver.
Next. Share the patient capacity का हमने class में किया था. That somebody has the capacity. To make
Capacity.
if he has the capacity to make decisions, then the person himself can override
Can
it.
override.
ठीक है. If it is contrary to law क्या हो सकता है? Assisted suicide. That if I have an acute episode, then I may be subject to euthanasia. नहीं हमारे को आज से 10 साल बाद हो सकता है. रात की डेट में एडवांस देखते हो आपका भी है. आप अपनी फॉलो कर सकते हो. Against it. Next. Shall not apply to the emergency.
Emergency.
It is the duty of the medical officer. ठीक है, to propose अगर treatment in accordance with medical care, ठीक है, उसके साथ में देना emergency nearby treatments में for example, a person has advanced directive that I should not be hospitalized for my treatment. Okay. So you think that hospitalization is necessary, required.
So I read that the emergency treatment is also applicable only for 72 hours. Then we have to.
Yes.
So they will.
Then we have to get the permission from
Emergency admission. Emergency treatment can occur in someone who is having a voluntary admission. Or maybe emergency situation arises. So emergency situations are different.
he may have given an advance directive that I should not be given any sedating medication. He comes in dystonia. You have to give that on OPD basis. So that you have to give. Okay. So you may not have to hospitalize him. If you are hospitalizing against the wishes, then you have to give permission 90 meters.
Then section change हो जाएगा, वो different चीज़ था, which will deal later. Next period. Next slide. Child वाला लिख के फिर parents have the capacity to make an advance directive for children. That means all the kids who are born will have to give, as a guardian, will have to give their,
We can give.
they can give.
Advance directive. One child should not be given ECT, one child should not be admitted or given whatever.
And legal guardian means I can nominate myself. I can nominate myself as a nominated representative in case of compliance. वैसे तो आपने nominated representative लिखा ही है, legal guardians are themselves nominated representative. Advance directive is will have to actually give it in writing and then the nominated representative is that you have to actually get it done in paper and sign it. And then I have to actually submit it.
Mental.
यहाँ पर तो we can start doing it at least कि जो साथ के गार्जियन हैं हम उनको nominated representative हमारे पास भी बॉडी तो है नहीं but at least हम एक केस में लिखवा लें कि भाई आप केयर करें at least तो प्राइस we can start it otherwise we will not get the habit.
हमारे पास है भी कि ऐसे हम लोग करते हैं कि कैरियर होना चाहिए साथ में. At the time of admission, you need to who is going to stay, who is the relative, you have to stay. It's our responsibility. But you have to stay with the patient, and maybe have to take it to them. Like the strain of yeah, the मान लो वो किसी
This is important because of the nominated representatives हैं, they are denying the not to restrain the patient. Then the sister in charge comes and complains कि guardian बना कर ले, guardian बना कर ले. So the other nominated representative, they are saying no, what we can do? One, the legal position to at least have an harmonious message to every section of the department that okay, this is how it is. Then we can't go and argue with the family members and all. We can counsel them to change the decision. But I think this is right in at least perfect our patient style.
Restraint. वो हम मदर नहीं अलाउ करें दूसरा जो केयर गिवर समझ करना पड़ेगा.
At least उसमें एक जो सबसे समझदार है उसका